I am honored to be here and speaking to you all about trust. I'm going to assume that I have screen share capabilities. So, okay, Leslie's nodding her head. So let's just jump right in. Okay, so we're talking about trust today. And my agenda for my presentation is to talk with you about what is an estate. And you may wonder why an estate is part of the conversation about a trust. And it is. And that's just the way it works. I'm going to let you know a lot more about that during my presentation. You're also going to learn what happens to your estate if you become incapacitated. Now, incapacitated is a legal term for you've lost your marbles. And I'm not talking about you forgot where you put your glasses or your car keys. I'm talking about you've got some cognitive impairment that prohibits you from being able to manage your life. Usually a doctor determines that. You're also going to learn what happens to your estate when you die. There are a couple of different options, and the options depend. And finally, you're going to learn the best way to plan for your estate. Any questions that you have, please feel free to throw them in the chat and I will address them at the end. So let's get started. What's an estate? An estate is essentially everything that you own. Listed on the right-hand side of this slide are assets that are part of your estate. Some are pretty common sense: your home, your stocks and bonds, life insurance. Technically, your retirement accounts are part of your estate, but as Lori explained, they're not necessarily part of a trust. There are also assets that are in an estate that you may not think about. Things like jewelry, a wine collection if you have one, artwork, antiques, furnishings, those are all part of your estate. And everybody has an estate. So some can be smaller, some can be larger. It just depends on who you are and what you own. Let's talk about your estate and incapacity. So remember, this is the situation where you're alive, but you've lost your marbles. If you don't have a trust or estate planning documents in place, what's going to happen is something called a conservatorship. Now, a conservatorship is an ongoing, it's not a one and done, it's an ongoing court supervised process. It's overseen by a judge. And it allows someone to manage your finances and possibly your medical care. The downsides to having a conservatorship are that the conservator, or the person who's going to be in charge of your finances, has to hire an attorney. There's no way to DIY or do it yourself in a conservatorship. And it's actually your estate. It's your money that pays for that attorney. Attorney rates in Moran are anywhere from $200 to $700 an hour. And finally, conservatorships are a matter of public record. What that means is that anyone who knows where to look can find out personal information about you and your estate. Now, you can avoid a conservatorship with a revocable trust, and I'm going to talk about trust in a lot more detail. Let's talk now about your estate and death. So this is the scenario where you are no longer with us. Under California law, you have three options. Option number one is you have no plan. So there's no document, there's no will, there's no trust. In that scenario, California law decides what happens to your estate. If you have only a will, then your will is going to be subject to probate. If you have a trust, a revocable trust, that allows for your estate or your assets to be privately managed. Before we talk about the various options, let's just make sure that we're all clear on the differences between wills and trusts, because they kind of do similar things and it's a little bit easy to get confused. A will is a document that transfers property at your death. So that means it's only effective at your passing. It has no legal consequence while you're alive and while you have your marbles. A trust, unlike a will, is a document that actually allows for property management during your lifetime. So if you lose your marbles, someone else can manage your trust property. And a trust also provides for transfer of that same property at your death. Option number one. So remember, this is the option where you have no plan, you have no will, you have no trust. What happens in this scenario? In this scenario, California law decides, and where your estate is going to go is dependent. It's going to depend on whether or not you're married, whether or not you have children. So let's talk about the scenario where you're married. You have community property or property that you earned or acquired during your marriage. In that case, then all of your community property is going to go to your spouse. If you have what's called separate property, maybe something that you owned before you got married, something that you received as the result of an inheritance or a gift, if you have no children, then 100% of that's going to go to your spouse. If you have one child, only 50% of that separate property is going to go to your spouse. The other 50% is going to go to your child. If you have two or more children, then only 1/3 of your separate property is going to go to your spouse. The other 2/3 goes to your children. And if your children are under the age of 18 in California, they're too young to receive an inheritance. So you're looking at another court supervised process called a guardianship. Okay. What about the scenario of you have no plan and you're not married? Who inherits that? Well, the answer to that is it depends. What it depends on is who is related to you by blood and living at the time that you pass. So it could be elderly parents. It might be your siblings. It might be more remote relatives like nieces and nephews or cousins. It all depends on who's alive when you die. And none of these transfers happen automatically. All of them are subject to a process called probate. Let's talk about probate, because probate applies if you have a will. So having no plan is not a really great idea. Having only a will is an improvement over not having a plan at all, but it's perhaps not the ideal estate planning tool to have. So the disadvantages to having a will are that it's like a conservatorship. It's not an automatic process. It requires a court supervised process called probate. Probate, like a conservatorship, is a matter of public record, and it's really expensive. Let's be specific about how expensive it is. Let's say that you have a $500,000 estate because you own a home in Marin and you have a bank account and an investment account that Lori's managed for you and it's produced well. If you have a $500,000 estate and you have only a will, your estate is going to pay $13,000 in attorney's fees to someone like me. Your estate is also going to pay $13,000 to the executor or the person in charge of your will. And then there's about $2,000 worth of court fees on top of that. That's $28,000. That's not going to your people or your charities. Though that's just the administrative cost to get your will admitted to court, proven to be valid, and for all of the necessary steps of probate to happen. And on average, probate takes anywhere from 12 to 18 months. I have a probate case right now, and we are at the end of the probate, and we filed a petition with the court clerk to close the probate. My client and I filed the petition in December of 2022. My hearing date with the judge on that petition is July 5th of 2023. December to July of the following year. Meanwhile, that probate is still open. No one has gotten their money because the judge hasn't even seen the petition. So I have a couple more stories about probate to share with you. My first story is a really sad one. In this story, the decedent, or the person who died, was a 40-year-old man. It was unexpected. It was quite tragic. He didn't have a will. He didn't have a trust. What he had was a whole lot of debt. The administrator of his estate is his mother, who is my client. And we started administering his estate. He died in 2021. It's almost June of 2023, and we're still in court. We're not done. And this is not complicated exactly, because he didn't own a whole lot of stuff, but there's a lot of debt that we have to deal with and a lot of problems. This entire scenario could have been avoided if he had had a will or even had a trust. If he'd had a trust, we wouldn't have been in court. And if he'd had a will, we would have a better job of getting the assets. The people that inherit are his 3 minor kids who live with his ex-wife. So it's a really sad story. My second story about the evils of probate is a 2-family story. It starts with an uncle who had a will. His will said, I give my interest in this family business to my sister. Okay, pretty straightforward. The client is his niece, who is the administrator of his will, simply because she wasn't named in the document. We open his probate, and his sister, my client's mother, lives long enough to inherit the interest in the family business. But the problem is, because it's in probate, it hasn't actually distributed to her. It's like it's going to come to her, but she hasn't received it yet. 5 months after her brother dies, she dies. Now, she had a trust, but she hadn't actually received the asset to put it into her trust. So now my client has another probate for her mother who didn't have a will but had a trust in a different county for the exact same asset that we're probating in the uncle's estate. And it could have all been avoided. If the uncle had a trust, we wouldn't have been in probate in the first place. If the sister had a more comprehensive estate plan, we wouldn't have to go to probate to get it confirmed to her trust. So those are two examples of how not having the right plan can cause your loved ones or whoever's handling your estate on your behalf a lot of heartache, a lot of grief, a lot of time, and a lot of money. Let's talk now about option number 3, which is the option where you have a trust. Okay, and part of understanding a trust and how it works is to talk about some important definitions. For purposes of this presentation, I'm talking about a revocable trust. And a revocable trust is essentially a trust that can be changed at any point in time. A revocable trust has a lot of also known as, so I think Lori referred to it as a living trust. You may have heard it referred to as a grantor trust. You might have even heard it referred to as an inter vivos trust. They all mean the same thing. They mean a revocable trust that can be changed. So as long as you are alive and you have your marbles, you have legal capacity, you can change your trust. Now, the person who makes the trust is called the trustor or the settlor, and the person who's in charge of the trust is called the trustee. And the beneficiary is the person or the charity or even a pet who benefits from the trust. And initially, in setting up your own revocable trust, you may be wearing all 3 hats. So what's so great about a revocable trust? What can it actually do for you? Well, number 1, it saves you money because you're not paying probate fees. That $28,000 that I talked about in an earlier slide, it doesn't cost you that much to put an estate plan together, and it's unlikely to cost you that much to administer your trust. So it's an automatic savings. The trust also saves time because it avoids a conservatorship where you're alive, but you've lost your marbles. And if properly drafted and properly funded, it can avoid probate entirely, right? It saves hassle because there's no court involvement. If you work with a competent attorney who sets it up correctly and gives you instruction on how to fund it, move your assets into it, if you work with someone like Lori to get support in that, the judge may never know any of the details about who you are, what you have, or who's going to get it when you're no longer with us. A trust allows you to transfer everything, not just the financial assets, but your grandmother's wedding ring, the china that you inherited from your aunt, your photo collection, your wine collection, allows you to transfer everything to the people or the charities that you choose. It also allows you to financially provide for your spouse, your children, regardless of whether they're young or older, your grandchildren. You can even provide for your pets. So what do you do if you're in charge of someone else's trust or will? I know that was a question that was asked earlier. The number 1 advice is to get professional help. Find a financial advisor, someone like Lori, to give you financial guidance. Hire a tax advisor, a CPA, an enrolled agent, to make sure that you understand what you're doing. And you also need a legal advisor, right? Someone like me to assist you so that you know what your rights and responsibilities are. And if you're in charge of someone else's money, you don't usually have to pay out of pocket to get this advice. You can use the money that you're managing to make sure that you're doing your job and doing it correctly. Because the worst case scenario is if you do something wrong, you could be sued. So you could find yourself in front of a judge, and depending on what you might have done wrong and how egregious it is, you may personally have to reimburse the estate for the harm that was caused. So avoidable situations by having the right team in place. So in summary, you've learned today that an estate is everything you own. You've learned that what happens to it depends on the documents that you have, or even if you have any documents at all. And really the best way to plan to create a comprehensive estate plan is to talk with a trust and estate attorney, whether that's someone like me or someone else. And Joanne had mentioned, it's important, and Lori as well, it's important to interview an attorney and make sure that you have a good fit. I offer prospective clients a complimentary 20-minute phone or Zoom consultation to, get acquainted, kick the tires, because where planning can go wrong is when there's a breakdown in communication. And I've been on the back end of clients that come to me and say, I have an estate plan, I haven't looked at it in 10 years, here's what it says. And before we go any further, I will say, well, that's great, but I'd like to see the documents. Let me confirm what it says, and then we'll reconvene and chat. And there have been a lot of times where what people think their trust says is not what it actually says. And that's a problem. And maybe they didn't feel comfortable talking with their attorney. Maybe they were afraid they were going to be charged by their attorney if they asked a question. But in my experience, that's a bad plan. And as you can tell from my stories about probate, if we can avoid court and avoid that complication, let's do a good plan. Because a bad plan means that we're in court trying to solve a problem that someone with expertise should have anticipated and should have avoided. And I'm going to stop my share right there.
Thank you, Carolyn. That was really, really great information. I see there's a bunch of questions. Joanne?
Yeah, fantastic. Thank you both, Carolyn and Lori, for breaking it down into really digestible pieces. Really appreciate it. So a couple questions here. Can you sell the property during probate?
Yes.
Okay, great answer. If you have a partner, but you're not married, does the state of California consider you married if you've lived together for 10 years or more?
From a trust and estate perspective, no. So spousal rights are conferred on either registered domestic partners or actually married couples. There are different sort of common law spouse rights that crop up in family law, but from sort of the who inherits question, no.
Okay, great. Can you talk a little bit more about conservatorship regarding a spouse that might have Alzheimer's or dementia?
So if you and your spouse had an estate plan that included a revocable trust, you wouldn't need a conservatorship. But if you don't have a trust and you have a spouse who has lost capacity, then yes, you would need to hire an attorney to be appointed the conservator of your spouse, because just by virtue of being married to someone doesn't confer the legal authority to make financial or medical decisions on behalf of your spouse. So, for a jointly titled asset, if both names are on it, then you're sort of allowed financial management because you're deemed to be a co-owner with the other spouse. But, yes, a conservatorship would be necessary. I don't actually do conservatorship work anymore, but there are several attorneys in Marin who do. What that looks like is you hire an attorney, you file a petition, the court's involved, there's a court investigator, the physician or physicians plural would need to assess and confirm that there's an infringement on capacity. And it gets a lot more complicated if the person that's the proposed conservatee who would be subject to the conservatorship doesn't agree with it. So it's a solvable problem, but it's an utterly avoidable problem if you put an estate plan together as early as, young adulthood when you have little kids, because you can put a plan in place and, life changes, your net worth goes up, your net worth goes down, someone that you've picked to do something, relationship changes, they die, they move away. Those are easy things to change as opposed to sort of trying to create the universe.
All right, looks like we have time for one more. What is the difference between a living trust and a life estate?
So a life estate is an inheritance that's contingent upon someone else's death. There are usually a lot of restrictions regarding what a tenant in a life estate can do. And they used to be a lot more popular than they are. They've really kind of fallen out of favor. Having a trust would provide a lot more sort of flexibility. I had a case where my clients were the two daughters. the stepmom had a life estate. It was a really old document. And basically what it amounted to was the stepmom got to stay as a life tenant in this property, even if she didn't live there, for the remainder of her life. And there was some complications with the type of property and the insurance, and it was sort of a nightmare. And my clients were like, well, can't we do anything? It was like, well, no, because you're stuck with a life estate. So they achieve sort of similar objectives, but I think a trust is better than a life estate.
And I apologize, I guess we do have time for more questions. So that's great because there's more in here. So what is the time limit for review of the existing living trust?
There's no time limit. Once a trust is made, it's valid unless it's revoked or distributed. What I tell my clients is if you make a trust, you file your taxes every year. You don't have to read your trust every year, but hit the high points. Who did you pick to do something? And do you still like them? Are they still in good health? Are they still in the country? Think about who gets what, and does that still make sense, right? And if you kind of ask those simple questions and nothing really has changed, then you wouldn't need to update your trust. Opportunities to update your trust would be changes in net worth, changes in tax law, changes in your life. You included your best friend in your plan and you had a falling out, and you're never ever going to speak to her again, and she's got to come out. So those are the opportunities.
Very, very personal, isn't it? Wow. And you may have answered this, but there is someone on the call that their dad has dementia, and before he could no longer make any decisions, they became the successor trustee of his living trust. Are they considered in charge of the living trust?
Generally speaking, yes. There may be some specific factors related to this particular person that I can't say, absolutely unequivocally. But that's a typical scenario that I see oftentimes in my practice. Parents make a trust. Parents are no longer able to manage it. They voluntarily step down, and the person in the wings steps up to the stage.
Great, thanks. And there are some questions relative to the cost of an attorney to create a basic living trust. Is there any range that you can give us today?
Sure. So some attorneys charge hourly fees to put together estate plans. For my practice, I do it on a flat fee. So for a single person comprehensive estate plan, for example, my flat fee is $3,500. For a married couple, it's $4,500. It depends on the attorney that you're working with. It depends on where your attorney is located, and it really depends on what you need. It would probably be a little more expensive if you've got an existing plan that you want to have looked at and then maybe revised, but not everything revised. So, I would say a conservative estimate is a few $1,000s. I have colleagues in Silicon Valley that are, charging $6,000, $7,000. There's a wide variety in the Bay Area. It just depends on who you are, what you have, and kind of what you need.
And going back to Lori's peace of mind, it's worth every penny, right? Just to have that peace of mind. And that's what I'm gaining from today. And there's a question in here. I'm not sure I completely understand it because it says, what do you feel about SW platforms to create a trust?
That was me.
And that's Cecilia, and I don't know what SW is.
Software. I meant online.
Software.
There's those create your own trust for, $595 kind of thing.
So I'll answer your question, Cecilia, with a little story. My story is some clients that came to review their existing estate plan. The husband was an intellectual property attorney, so very smart guy in a very niche legal industry. His wife was a CFO. So certainly people that had a lot of brain power between the two of them. They had done their own estate plan. And I congratulated them for having something, because something is always better than nothing. And they said, this is what our plan says. And I said, okay, great, let me look at it. And when I looked at the plan, I went, okay, it didn't say anything like what they thought it said. And when we had the meeting to talk about their plan, their jaws hit the floor, because I said, well, this document does this does that. And it was like, that's not what we want. So that's okay, because we're here and we're not going to fix it now. Generally speaking, most people, I don't generally recommend sort of doing it yourself, because there's a lot of pitfalls and everybody thinks that their stuff is really simple. I don't know, Lori probably hears this as well. Oh, it's really simple. But as
That's
she
great.
mentioned, the answer to lots of questions is it depends. And so I think that's really the benefit of working with an attorney is that, they've gone to law school, they practice in trust and estates, they know what you don't know. And so they're going to make the process easier, right? So yeah, I generally, I've had a lot of people that have tried to do stuff themselves and they bring it to me and it's like, it's a nightmare. And they're lucky that they didn't lose their marbles or die and have to deal with the documents that they have.
Okay, there's something in here. Susie Orman has a living trust platform, ?
I believe she does. I know Suze, I know the attorney that she worked with to draft her platform. That might be appropriate for potentially more simple, maybe you have just a home and, sort of straightforward assets. But if you're trying to plan for children, if you've got investments, retirement accounts, if it's a blended marriage, kids from a prior marriage, if you've got community property, if you've got separate property, multiple properties, I think that there's a lot that those kind of programs that, you can't just put the slot, the tab in the slot and have it all magically come together.
Yeah, and that would, for me, it's all about relationships, you know what I mean? And you're really entrusting someone to, handle something that's very personal and very sensitive and may have to change repeatedly over time. So I can see that for sure. Well, Cecilia's raising her hand over there. Yes, ma'am.
Yeah, we have time for one more question. I would like to ask it.
Go for it.
And then of course, what is the question, Cecilia? I just lost it. Gosh darn it, Joanne.
So sorry, Cecilia. Well, maybe we'll come back to you. I want to thank Carolyn and Lori so much for today. This was, I gained so much information. I'm really excited. I do not have any of the check boxes at the very beginning question, which is now scaring the living daylights out of me. But this was good because this is a good start. You made it seem very comfortable and easy. And so I appreciate that so much. And Cecilia, did you remember your question? Yes, of course you did.
I did, because my husband and I do have a trust. One of the tips that our attorney told us, and I will share it with you all, is that you should be looking at the younger generation for people who are going to be doing your trustee if you should pass, because if you choose your friends, they're going to be passing around the same time you are probably. So I thought that was interesting because I didn't think about that. So now we're nurturing all our younger generation in our family to see which one pops up as the smartest.
That's fantastic. Well, thank you again. I appreciate it. I think we got to all of the questions. We will send out the Lori and Carolyn's contact info to all of you who attended this evening, as well as the slide decks, if that's okay with you too. I just wanted to invite everybody to our June meetup, which is June 14th at our Leader Circle Bank of Marin right here in downtown Center Falls on 4th Street. I'll put the link to it in the chat, as well as the Chamber All County Mixer. So every year all of the chambers in the county get together for networking, and we are meeting at the Lumber Yard in Mill Valley at the end of July, and I'll put that in the chat as well. And please save the date for our Women of Industry celebration on Tuesday, October 25th. We are returning to the Jonas Center, and nominations for Women of Industry honoree will be out soon. And Cecilia, did you want to do your chat?
Oh, okay. So at the very end of our webinars, we've been doing these wonderful little things called waterfall chats. And what they are is we're going to ask you a simple but inspiring question, and we want you to share 1 to 3 words answers in your chat, but we don't want you to send it. So the question that I'm going to give you is, now that we've learned all of this information about and definition, I think, which is so important, about trusts and wills and probates and conservatorships, what do you find to be the next thing that you're going to do either for yourself or for your family or for your kids. What's the next step you're going to take with all this great information? And write it in the chat, but don't send it. Okay, does everybody have a thought in there? All right, so hit send. Oh, wow, I'm going to try to, oh, that's a long one. Revisit, now reviewing my existing trust, be more proactive, check my trust. There you go. Awesome. Well, this is great. This shows you that people were listening and taking notes and thinking about their next steps. Carolyn and Lori, fantastic job. Thank you for all the kudos about the Leadership Institute from the Leadership Institute grads on this particular webinar. Thank you to Joanne Webster. Under her leadership, the Women's Empowerment Series and the Women of Industry initiative has really grown over the last, I don't know, 7 or 8 or 9 years now. So we're really happy to bring this to you, and I'll let Joanne do the last closing remarks.